There is a moral value in addition to the more fundamental guarantee of human dignity to each employee in the pluralistic encounter of diverse employees at work. And it also helps, as J.S. Mills observes, community to engage multiple perspectives. Asha Rao, who has done on, NMCs in India and also in America, she feels that after her empirical work, I felt really that such work should really lead to some more work because she has only interviewed the employers. She feels that it is important for managers to proactively develop their firm's policy on religion in the workplace and try to build synergy on religious differences in the workplace and in the sphere of public life. Religious identity does not trump citizen identity. Thank you so much. I have saved 3 minutes.
The grand finale for today, Professor Vasanthi of NALSAR. Yeah.
Respected Chairperson, dignitaries on the dais and off the dais. Let me begin by again thanking Professor Mustafa for inviting me to speak on the issue of religion at the workplace. And what I am trying to do in this paper is perhaps give an overview of the interfaces between religion and workplace in India. I think what is evident from the talks that we've had since yesterday is that the issue of religion in the public place is a very important issue, notwithstanding that the Indian Constitution is a secular constitution. I think it is very clear that the definitions of secularism that we have been using in the Supreme Court are so varied that on the one hand we talk about the wall of separation, and on the other hand we say that we need to distinguish it from the wall of separation. We talk about it as a toleration of all religions as well as that the state does not have a religion. These conflicting opinions on secularism also reflect what the inaugural address was pointing us to, that the secularity that we see in other parts of the world has not really occurred in India. And so then the decision that was referred to even yesterday, that even today the issue of appealing to voters on the basis of religion is still litigated and it's a contested space, because on the one hand we do say that we are not overruling the Hindutva judgment, and then we say that yes, you can't appeal to voters on their religion. This ambivalent position of religion in the public sphere also reflects in the law relating to the workplace. The workplace, as has been pointed out by earlier speakers as well, is a public space and must necessarily balance the freedom of expression as well as the right to religious freedoms that are guaranteed in Part 3 of the Indian Constitution. However, since the state may not make any law that is in violation of these fundamental rights, labor legislations in India are largely what we understand as secular legislations, in the sense that there is really no mention of religion in any of these legislations dealing with workplace rights. But all of these questions, whether of secularism or of fundamental rights, typically in the Indian context operate only in what we understand as the organized sector. So the unorganized sector, which composes of almost 90% of all the workforce, is a sector which is in that sense free from influences of any kind of secularism or of fundamental rights or basic rights at work. Now, in this context, how do we look at the operation of religion in the workplace? And I will very briefly try to look at all three contexts. So in the first context, we have organized labor, where we have the question of fundamental rights being applicable. And then I will try and look at the unorganized sector and how informality deals with the question of religion. The one case which again has been referred to by many speakers since yesterday is the Mohammed Zubair versus Union of India, wherein the Supreme Court had ruled that you cannot, that a person belonging to the Muslim faith cannot wear a beard. Now let me spend a minute going into the details, because none of the speakers really refer to the details of the case or the legal question that was involved here. The question concerned Regulation 425 of the regulations of the Indian Air Force. Now, this regulation in itself is an anomaly, because under Article 33 of the Constitution, the Parliament may modify the rights conferred under Part 3. So, legally speaking, the Parliament can say that none of the rights that are available, whether of equality or non-discrimination or religious freedoms for that matter, are available for the armed forces. In spite of that, you do have the regulation which starts off with saying that the person of the armed forces must be clean-shaven. But then clause B starts off with saying that the growing of a beard by those personnel whose religion prohibits the cutting of the hair or shaving of the face of its members will be allowed. And so here, in spite of the legal position that you could have modified religious practices and the profession and the practice of religious freedoms, you do see an accommodation. But then this accommodation, the appellant claimed, was not being availed of fairly, because you had those personnel whose faith compelled them to wear the beard, and those personnel whose religion only said that the growth of a beard was desirable and was not compulsory. So in spite of the fact that religious freedoms do not operate in toto here, you do see the court deciding it on something that we've all been talking about since yesterday, and that is the essential practices doctrine. So we come back to the question of whether something is an essential practice or not for it to be tolerated, rather than to see how the workforce needs to deal with questions of individual freedom and to what extent the workforce or the workplace is impacted by the exercise of certain freedoms. And here perhaps you see that the line taken by recent decisions of the European Commission on Human Rights has moved away from the essentiality test, and to say that as long as there was no requirement to establish that he or she acted in fulfillment of a duty mandated by religion, but instead said there is sufficiently close and direct nexus between the act and the underlying belief, assuming that the belief is also judged to be both cogent and important, is sufficient to establish that a claim is a bona fide one. This, as I said, I'm only posing questions or looking at how the Indian Supreme Court has dealt with questions of religion at the workplace, and we find that the Supreme Court by and large conforms to the broader principles of what is an essential practice, rather than to see whether it is something that concerns freedoms, as was being pointed out, and liberty rather than equality. Now, if you move to the other half, or not even the half, the dominant paradigm in which most Indian workers work, which is that of the unorganized labor, here we find that it is secular in the sense that the question of religion is not overtly addressed at all, which also means that it is free for employers to hire persons or not hire persons on the basis of their religion, and excepting for the law on sexual harassment and discrimination on the basis of sex, there is no law dealing with other forms of harassment or other forms of discrimination, including caste-based discrimination, which has raised many disputes recently. But on the positive side, because the law relating to collective bargaining allows for agreements to be entered into between the employers and employees across industries or in a particular organization, and these agreements have the force of law, they have the potential to cater to issues of religious accommodation if there is a consensus on it. Local and customary practices such as festival bonus, festival holidays are claimed by workers as a matter of customary practice rather than as a matter of state-made law. The other interesting intervention which has been used by religious bodies has been the Trade Union Act, which says that any group of 7 persons may form a trade union. They don't all have to be workers, and they don't all have to be employed in a particular industry. And the definition of industry itself has been so wide as to include religious institutions. Perhaps the biggest religious institution, the Tirumala Tirupati Devasthanam, has been held to be an industry, and all its workers have been held to be employees who can form trade unions. The other way in which the Trade Union Act has been used has been with the National Domestic Workers Movement, which was founded by Sister Jean DeVos, who was moved by the facts revealed by the subhuman conditions of domestic workers in India by a survey that was conducted not by the state, but by the Catholic Bishop Conference of India in 1978, following which the movement was founded in 1985. And she says that I felt that my actions should empower the most vulnerable and discriminated. For this reason, I opted for domestic workers, be they women or children, because they had no voice, no rights, which is my understanding of slavery. What got me working was the inhuman situation of those women and children, and it hurt me as a woman. The NDWM partners with Dan Church Aid as a part of the ACT Alliance, and it has also encouraged its members to set up trade unions. Swami Agnivesh's work on bonded labor is also one such initiative that we have seen where religious bodies and religious persons do actually interrogate labor rights as matters of basic human dignity. But as a concluding caution, remark or comment, the kind of work ethic that we are talking about, that we're looking at in other countries and looking at in India, must perhaps, and you can correct me if I'm wrong, but the kind of hierarchies between different works that we have in India, the negative attitude attributed towards manual work or even care work, given that most women's work is not even considered as work, it is difficult for us to say that a break has occurred from tradition, which has occurred in other countries, in other parts of the world, leading to workers as a social force. And when this has not happened in India, and Dalit autobiographies, Dalit movements have only described work as slavery, or have described work as performing caste-based duties, have described work as being degrading, it becomes very difficult for us to look at an idea of the emancipatory nature of work. And as I said, I will simply leave this as a question or as a comment which other people can take forward. Thank you so much for your patience.
This is a very interesting theme, the wisdom of reasonably accommodating religious sensibilities in the workplace. Because in Indian history, the one instance when the East India Company did not respect religious sensibilities, we had our first revolt of 1857. So I think it opens up very interesting questions. So do we have time for 10 minutes for questions? Comments? Anything but alternative formulations? Yes, please, Professor Mustafa. Yes.
Madam Chairman, I would like to submit that when we are discussing religion and workplace, we should certainly discuss how accommodation for religion should be given in the workplace. But we should also discuss how religion can help in the workplace. For instance, in hospitals, when nurses comes, a Muslim nurse comes, ye namehram hai, ye hai, ye wo hai. Hindu nurse comes, hum to Brahman hai, hum ye kaise chhuye. If we accommodate all those religious susceptibilities, then where will nursing go? Only Christian nurses take their job seriously, honestly, sincerely, and nobly. I salute the Christian nurses and I pay my respect to their religion, Christianity, which tells them to serve the sick, to tend to the ill. Similarly, I would expect Islam to play a positive role in the workplace by telling its followers to work hard, sincerely, honestly. If Muslims are only going to ask for time for prayers, for Zohar prayers, for Asr prayers, I think they will be making a nuisance of their religion. Aslam Sahab has pointed out about that beard. I would like to ask whether that person who wanted to keep a beard, does he follow the Shariat in every way? Does he never see a movie? Does he never listen to music? Does he never see dancing? Does he never do anything against the Shariat? And how does suddenly a person become so serious as to want to keep a beard? The problem in the Air Force is that there should be 15% Muslims and they are not even 1%. Our concentration should be towards creating more Muslims, getting more Muslims into the Air Force, not just helping one Muslim to keep a beard. I am sorry, I generally take the opposite view. Thank you.
Okay, I would like to refer to the last part of Brett's presentation. It may have to do also with the last remark. Brett was correct in stating that equal treatment of unequal persons leads to inequality rather than to equality. But there is more to that. Very often, seemingly neutral rules cover up actually discrimination. And what I have in mind is the famous case of Lieutenant Simcha Goldman. Goldman was a religious Jew. He was actually a rabbi. He served as a psychologist in a air base in the United States. The rules of behavior there were that if when you are out of the office in campus, you must wear your army hat. When you enter an army building, you must take it off. Simcha did it. When he entered his office, he took off his hat and put on a yarmulke, which is a small head cover that religious Jews are supposed to wear. The commander of the base, who had some disagreements with Simcha, told him that he can do one of the two things, either take off his yarmulke or leave the army. The case was brought up to the Supreme Court, and surprisingly enough, this provision of this rule was upheld, again, I think by majority of 9-1, when Chief Justice Rehnquist said that the rules are neutral, because the rule said that only invisible religious attires can be worn, and certainly the yarmulke is visible. The minority judge, however, pointed out to the fact that this rule fits the Christian attires, because you can always hide the cross behind the shirt. You can't do it with the yarmulke. However, it didn't work. I made my way from Australia to San Diego for a conference of drafters of a model constitution for Israel, and I had to speak about religion and state. And on the airplane, I just picked up the paper from that day and found out that the American Congress passed a statute that did away with the decision of the Supreme Court. I remember when I spoke there, that was many years ago, I said that this is a rare case where the legislator is much wiser than the judiciary. My commentator was a judge of the Ninth Circuit. He was personally offended, but I insist on that. In this case, and it's a rare case, the legislature was much wiser than the judiciary. I don't know what could disturb army discipline if a person wears a little yarmulke. On top of the question of discrimination, I won't do it now here, but I went through the rules of the Air Force, and I found out many other provisions that seem to have been drafted by the Council of Christian Churches rather than by the commander of the Air Force.
Madam, I would recall what you said yesterday, that say in terms of army or air force or police, state is free to say that these are the set of rules. If you join us on these conditions. But what is happening when these things are being challenged, as the original case was not this Air Force person, because here the Air Force rule was not challenged. The original case is from Kerala, Fasi versus the state of Kerala, where the question which judge framed for himself was, is beard an essential Islamic practice? And he did not accept. Petitioner gave all the hadiths on the basis of which it can be proved it is an Islamic practice. That was the test which they had adopted in Shirur or Mutt case, that if we have to decide an essential practice of a religion, we will look at the scriptures of the religion to decide whether it is essential or not essential. Here they said, till date you did not keep the beard, why you want to keep it now? Now that question state or judge should not be asking, I was an atheist till yesterday, today I want to become a believer, I should be allowed to believe. Similarly, the judge, instead of looking at scriptures, in this case said, well, so many Muslim intellectuals and leaders don't keep the beard. So that is the whole problem, that courts have taken this responsibility upon themselves to decide what is essential and what is not essential, and they decide it not on the basis of scriptures but on empirical evidence, what other Muslims are doing. I think that is problematic. If the state says you want to join this, this is a contract. You sign this contract. On these terms and conditions you are in. If you don't accept these terms and conditions, you are out. There will be no problem. Therefore, the whole problem in our country, unlike in United States where you had such a one-sided judgment, is that these things are played out of context. And judges have overtaken, as Madam rightly said, the responsibility of reforming religion. Now that is not their job. And defining religion. So what you said about the South African case, it is better leave it to people, let them decide. Most of them will not keep beard. If one or two want to keep, let them keep. What is there?
Look at it, the colonial state, Oberoi has written this book on construction of religious communities, in which he said the notion of the Khalsa only becomes important in 1880s. Otherwise, Punjab, Muslims, Hindus and Christians lived well together, because the British Army said that if you have to join the army, you have to undergo Amrit Dharna, baptism. You have to become a Khalsa in order. So you had Sikhs becoming Khalsas in order to join the Indian army. And then, when Harjot Singh Oberoi pointed this out, and I said, here were these guys secularizing their own countries but imposing religion upon us. And in every cantonment, in every battalion, there will be a Gurudwara, temple, and perhaps even a mosque, if that's a Muslim regiment. So they pandered, they brought the religion onto center stage. And so the Supreme Court is continuing this project. But John, this will never end.
Discrimination. No, I will resist the question which needs to be asked, what time is dinner? But, and also, on the Supreme Court cases, all of the diciest cases, nobody asks, does the beard make you less of a fighter? Then why is the Sikh light infantry without a beard, but the Sikh Jat regiment is with a beard? And why is the Navy with a beard and the army without a beard, and do pilots take off their turbans when they enter a Mirage jet? There are millions of questions which are not asked. Qua the beard. As a keeper of a beard, I would have asked those questions. I may still ask those questions from a secular perspective. Is beard mandatory or a lack of beard mandatory under the Army Act? But this is not the thing. It's also about not commenting on the Supreme Court and disparaging the fact that a court which has no courage to define religion suddenly finds courage to define principles and essentialities of religion, and refuses to hear when you say, why is Christmas Good Governance Day? Every day should be Good Governance Day. But my biggest problem is with the accentuation and the deification, if I may call that, of accommodation, and the way it eventually will be used in countries which are, well, countries, as we have seen with tolerance. I mean, all of us here, sectionally, are victims of tolerance. And it's not called tolerance, it's called toleration, which is bad grammar. But why should we? Why is there no citizenship? Why is there no law? Why should I be at the mercy of somebody in the right and left accommodation you were talking of? Is accommodation the same as negotiation? Will this negotiation change with time, with evolution of society and presumably of law and legislative practices? Will tolerance change? Is it, when I was a science student, would say, is there a calculus of it? Is there a d by dt of tolerance, of accommodation, of all the things, the ingredients that go to make peace? The rest I reserve for my 10 minutes tomorrow.
with due regards to Sherwani साहब, जो आपने एक सवाल किया उसका जवाब भी आप ही ने दिया कि we should have 15%, we don't have 1%, और जो 0.0001 था उसको भी निकाल दिया. So that's a different thing, and my intention was neither to defend the case of the Supreme Court judgment. I was just giving examples that discriminations do happen, whether it is United States of America or it is India. I am not neither proving it whether it was right or wrong on the part of the Supreme Court to have done it. That this is which could be discussed, in greater detail. But discrimination does exist, and my proposition was let us acknowledge it. That's it. If we are in a state of denial mode, we will never reach anywhere. Let us acknowledge it, and once we acknowledge it, the second step should be let us address it whatever little way we can in our capacity, rather than waiting for the central, national, other governments to come for our rescue. Let us start doing somewhere. Let us create good examples of, say, starting with NALSAR itself, because they are hosting this international seminar. That we will introduce a pledge that at least within the boundaries of NALSAR, there will be no religious discrimination. And then we spread to other places. Thank you very much.
Accommodation will not really be a very helpful principle. There is tremendous discrimination. Accommodation comes after you've solved the problem of discrimination. And so if you're in a situation where people are being discriminated against on the basis of their religion in very fundamental ways, you have a much bigger problem than trying to accommodate special needs. And accommodation is not a principle that's going to solve every problem. But the question is, are there times when uniform rules create non-uniform hardships? And the example that Professor Maoz gave is a good one, of the prohibition on headgear in the Air Force. And it's instructive because the dialectic that took place was the Air Force said, we must have this rule in order to have uniformity and order in the Air Force. And the Supreme Court said, we agree. We're going to defer to the Air Force on this matter because of the specialized military context. There's a special need for order, a special need for discipline, a special need for uniformity, and because of these special needs, we're going to not weigh very heavily, or these special needs outweigh the need for an accommodation. And then Congress stepped in and said, this is silly. Of course you can have order in the Air Force and still allow people to wear a yarmulke. So they passed a statute saying, notwithstanding what the Air Force regulations say, you can wear unobtrusive religious headgear. And Goldman put on his yarmulke, and guess what? The Air Force continued to do business. The world did not come to an end. The accommodation was possible. And respect had been vindicated. The idea that a special need can be accommodated in a way that is hospitable was possible. Now, you talk about Pillay. One thing that's interesting about Pillay is the court said we don't care if it's a religious or a cultural practice because both are important. And they said we don't care if it's mandatory or not based upon someone else's understanding of what Hinduism requires. What we care about is that it's important to her, to Ms. Pillay. It was her dignity that was at stake, not whether her interpretation of Hinduism was correct or not. So I think we can learn from other courts in other contexts. Now, the final comment is a response to Indira, who I think was suggesting that this might be well and good in a place like the United States, but the idea of accommodation as hospitality would not be meaningful in India. Was that your...
The reasonable part of it. Many of the demands in India are unreasonable, but you have to agree because there are only people.
Yeah, I think the balance is going to be struck in different ways. I mean, in a way, it's easier to accommodate small minorities than large minorities. The issues of accommodation become more challenging when the minority is 30% rather than 1%. And so that's why I think we as Americans need to be a little bit less judgmental of the French as they struggle with issues involving Islam, because there's a much bigger challenge facing French society. But I would think that the ethic of hospitality would actually be quite appealing in an Indian context. When I think of accommodation as a right and an exception, I'm thinking of the predominantly American approach. That is how we think about accommodation as lawyers in America. The second approach, accommodation, reasonable accommodation as what the state can reasonably ask of you to change, I think of as predominantly the French approach. You've got this strong secularism, and the idea is we can require you to leave aside your religious needs, your religious difference, in the name of laicite, in terms of this important French ideal. And so I think of that as largely the French approach. When I think of the hospitality approach, if someone were to ask me, well, who does that? I would probably say, well, I think India tries to. I think India tries. And it's imperfect, it's difficult, it's not easy, and it's not going to be a one-size-fits-all solution, but I think India, to a remarkable extent, tries to say we are a society made up of many different traditions, many different histories, many different needs, and let's try to accommodate those different needs. So don't give up too quickly on this idea of hospitality, because I actually think you are better at it than most of us are.
Thank you. Thank you so much. Just two quick announcements. We are behind schedule by 1 hour. So we'll immediately go have our dinner. And tomorrow morning, those who are staying here,